Now, a court ruling has set in motion big changes for parental leave in South Africa. Sections of the Basic Conditions of Employment Act have been ruled unconstitutional. Under interim conditions, parents of a natural birth will be able to determine how the 4 months of leave is doled out, removing the false caregiver roles pushed on mothers and fathers. Parents of surrogate children and those who adopt children under the age of 2 will be granted the same parental leave rights. All right, let's discuss this new court ruling, as it may be a huge win for parental leave in South Africa. Global Business Solutions CEO John Botha joins me now to give us more on his analysis. Mr. Botha, thank you very much for your time here on eNCA. I must say, I'm enjoying this story. We've taken long, but obviously, it's still a learning curve. It shows that our democracy is working in South Africa. The law is moving.
Absolutely. Good afternoon to you and the viewers. Well, effectively, they were saying the current provisions in the Basic Conditions of Employment Act are unconstitutional from the point of view of lack of human dignity and infringing the rights to equality. So a very important finding, and I believe a very necessary one, because it does away with certain stereotypes around the roles in terms of gender. It does away with an irrational additional leave for childbearing mothers vis-a-vis people who adopt or who have surrogates. So I think overall a good move. I think the big challenge is organizations are going to have to adjust really quickly.
And of course, there's still the discussion, I understand, and you could help me, because this is something that this is a ruling that I'm still reading and I'm trying to understand. Section 26 of the Act was also, governing, especially for nursing staff, etc., those 6 months, whether or not they can actually come back to work, how they use their money. Where does it put us there?
Well, that's a very good question. So the reality is, historically, up until this judgment, maternity leave was 4 months unpaid leave.
Yeah.
That was the minimum condition, and it was only for childbearing mothers. That 4 months has now been firstly extended for, as you said correctly, adoption, surrogacy, and also obviously maternity leave. So the reality is, as a parent, you are busy investing of yourself. You're sacrificing, you've got sleep deprivation, you're cleaning bottles, you're sharing duties and responsibilities. And what this judgment does is it says we recognize that same-sex couples, whether you're the father or the mother, irrespective of how you have incorporated this child into your world, the point is you are needing of 4 months. You can then decide, if there's more than one parent, you can decide on how to allocate that 4 months. And that's also a big change, because the one parent could maybe say, I want every fortnight off, and the other parent would then step in for the next fortnight. The only requirement is obviously to upfront advise your employer of those arrangements. But other than that, I think what it recognizes is that people, whether they're single parents, partners, same-sex, traditional, husband and wife type couples, childbearing or non-childbearing, the 4 months will apply. And I think it's highly justified.
And how important is it? Because, the law also stipulates that it is also the onus of the employer to ensure that their employees know their rights and changes to acts, etc. You know what I mean? How important is it for, businesses and employers to make sure that people understand, their workforce understands this new right and understands how time can be allocated differently to just taking the entire 4 months with no pay?
Yeah, that's one of the big challenges, of course, because the ruling made by the High Court becomes effective immediately. So just for purposes of clarity, the court's decision was to give Parliament 2 years so that they can align the Basic Conditions of Employment Act. But in the interim period, the High Court has put interim provisions in place, which are what we've been discussing. It's now 4 months for any of the instances. Adoption, surrogacy, maternity leave is all 4 months. Historically, adoption, for example, was 10 weeks. Surrogacy was 10 weeks. Parental leave was 10 days. Now, all of those instances attract 4 months leave, which is funded through UIF. So what organizations need to do very, very quickly, to your point, is they need to engage with their employees. They need to be clear in order to manage expectations and to adjust their policies internally. So it's something that becomes effective immediately, although we are waiting for the actual legislation to be amended.
And of course, I think what's important is for those who are going through surrogacy, etc., who are worried about what it means for them. We did see, for instance, the change with parental leave after childbearing. That was also something that was won in court because men, weren't given the ability to take that leave when they have a newborn in the house, to be able to help their wives, etc. So very important, and I think that's why I was saying, Mr. Botha, at least, it's taking long, but at least we're a learning democracy and we're seeing our mistakes.
No, you're spot on. And I think for a lot of people, it might be out of their comfort zone, but the reality is that the previous provisions enforced and entrenched gender-based stereotypes, which were not justifiable, they were irrational. And also, if someone brings a new child into their house, it's irrespective of how the child, whether it's by being the birthing parent, being adoptive or surrogacy, you all have the right of human dignity and the right of equality. And I think, to your point, the democracy is working in terms of sections 9 and 10, in this case, of the Constitution.
Mr. Botha, thank you so much for your time. That was Global Business Solutions CEO John Botha speaking to us there. You need to read the law so that you at least understand and you have the right questions for HR at the company you work for.